Growing international outrage over the NSA spying program. Allies like Germany are furious that their leaders may have been targeted, but they weren't the only ones. The Department of Justice says now, and this is very new, that it plans to use information gathered by our nation's spy agency to show the warrantless surveillance program is doing some good as evidenced against a terror suspect who's been busted. This could now open the door for a legal challenge that could land the controversial program directly in front of the Supreme Court. Might take a while, but, you know, things take a while. Doug Burns joins us, defense attorney, former prosecutor, and Richard St. Paul, who is a defense attorney as well. All right, so if you're the defense attorney for this suspected terrorist, the first motion you're going to make is to suppress evidence because you're going to say, Your Honor, it was illegally obtained, right?
There's absolutely no doubt. That's exactly the first step, because now, since the government has told you, now they've never said this before, they've never revealed that they got information from the warrantless surveillance program. So now you say, well, you get to challenge, now that they've told the defendant this, now you get to challenge how they got the information, and certainly that would be a motion to suppress. This information was illegally obtained.
Yeah, and I see, Doug, two defense challenges. Number one, the government failed to follow the FISA law properly, the Foreign Intelligence Surveillance Act of 1978, later amended by the Patriot Act. And the second challenge is, let's look at the big picture, Your Honor. The whole thing is unconstitutional.
But the problem is it's a little bit of a catch-22, as one commentator noted. Back in February, the Supreme Court handled the FISA case, and they turned around. It was amazingly ironic, and they said, well, you can't even demonstrate that this information came from a FISA warrant.
Because the FISA court's secret.
Leading to the response, well, how could I ever show that? Because it's a secret court.
That's right.
So the point is, and the government also uses 2 or 3 trump card phrases just routinely, both in a regular criminal case and with respect to FISA. Your Honor, this will compromise our investigation. This could compromise informants. And then with respect to surveillance, they turn around and say national security and terrorism. They just throw those terms in.
You know, there was another FISA challenge several years ago. It was U.S. versus Nicholson, and all of the challenges from due process to 4th and 5th, and you name it, they were all rejected by the court. Do you see this going any differently?
Absolutely. There was a challenge most recently in Clapper versus Amnesty International, where the court dismissed the case saying you didn't have standing because you were never under surveillance. There was no warrantless search. Well, now we have a defendant who we know was under surveillance under the program. Certainly he has standing in court to challenge the legality of the warrantless search and using the information against him.
Here's my question. Dating all the way back to the late 60s and early 70s, federal courts have consistently upheld warrantless wiretaps and surveillance in cases of national security. This goes even further. This one not only could qualify under those cases, it could qualify under the FISA cases. Right?
Well, that's exactly right. I mean, you're repeating my exact point, which is the minute you can legitimately, let's talk about good faith, let's assume that legitimately in good faith, it's a matter involving national security or, more serious level, terrorism, then courts are going to be extremely reluctant to overturn that.
Right. Now, if you're the defense attorney and you say, Your Honor, I want to see the evidence that that evidence for national security reasons is secret, what does the judge do? Does he go back to his chambers and look at it himself with nobody else seeing it?
Well, certainly. You can have an in-camera inspection, and you can have a heavily redacted document. There's a number of ways to do this, but that's an interesting point. So where does your constitutionality stop?
Right.
I mean, how do I properly prepare to defend my client when the government's offering information that I can't defend against? So that's the slippery slope we're facing that the Supreme Court will need to address.
Famous Supreme Court justice said, sunshine is the best disinfectant. We need to be open.
Oh, that's true.
Right?
Yeah, absolutely.
So how can Americans have confidence in a system that was set up to be secret?
This is a balancing test, obviously, between privacy, liberty, individuality versus national security. And the problem is, I love the fact that you guys are using the term slippery slope, because you don't have to be an expert on world history. The minute you start secretly wiretapping people, secretly doing things, it can be a tough slope.
All right. It's going to be interesting to see what happens. Two terrific lawyers, Doug Burns, Richard St. Paul. Good to see you. Thanks for dropping by.
Oh, thank you.
Okay.
My pleasure.